Um, Good morning, everyone. This is my second intervention in this event, and my last one, sure. Um, um, I'm going to talk about the new instrument that is preparing UNCITRAL on negotiable cargo document. But I would like to use 5 minutes to enter in the previous discussion. Um, uh, Remember my presentation yesterday? I put a slide saying new or disruptive technologies on commercial transaction, and one of those technologies was the electronic document, and the previous debate was very interesting, and only one thing about the discussion. The problem is we are using the word document. And when we use the word document, we are thinking, okay, possession, okay, paper, possession. But the correct word, under my point of view, is record, the electronic record. And when you use the term record, probably your mind is thinking on internet, on the digital world. So when you think on the digital world, the things change. And another point, another important aspect is the equivalent equivalence functionality, or the principle of functional equivalence. And why I say this is a problem, because we are in a debate with functional equivalence pending on our head, and we are. And my question is, what do we need? Equivalence, functional equivalence? And my answer is probably not. And why? I'm trying to explain this in a moment. When we use the term equivalence, we are trying to put the focus on the equivalence between the document, paper document, and a record, an electronic record. Why? We are dealing, I mean, and the reason is a PDF, sorry, is not an electronic document. Well, it's an electronic document, but it's not an electronic record. This is a scanned document, but not an electronic record. An electronic record is data are zeros and ones, on controlled by an algorithm, etc. But I mean, a PDF is not an electronic record, an electronic document. And the problem of functional equivalence was, as I mentioned yesterday, was very useful on the first stage of these disruptive technologies. At the end of the last century, with the UCC, as Professor says, the UCC of United States, the model law on electronic communication from 1996, the model law on digital or electronic signature from 1996. So in this first state of technology, the equivalence or the equivalence of functional equivalence, sorry, my all day with this term, was very useful. But today, why was very useful? Because our relationship with the technology, with the digital world, with the internet world, was very short. But now, 30 years before, we have documents or records that has born and live on the digital world. I mean, we don't need to transfer the paper to the digital world. So we don't need to transfer the paper that lives in the physical world to transfer to the digital world. We have instruments that has born and live on the digital world. Tokens, for example, such a very good example on digital assets. non-fungible tokables, fungible tokables, I mean, many other digital assets. And Professor previously mentioned the model law on electronic transfer of record. Under my point of view, and this is sorry for express this view, lose an great opportunity to rules the electronic records without without the obligations of the functional equivalent. And a very good solution, a good solution, I don't know if it's a very good one, but a good solution is the unit draft principles on digital assets. For example, in that case, unit draft principle on digital assets rules the control not as equivalence of possession, rules the control itself, but not as an equivalent of possession. Under my point of view, this equivalence probably is an error or is a mistake. Okay, I mean, sorry, and last idea. Imagine if you take a picture with your iPhone. If you take a picture with your iPhone, the picture is only a picture when you print the picture or when you show the picture in the screen, on the screen. But if you don't show the picture, if you don't print the picture, it's just data. It's just a record. I mean, so the picture is living in the digital asset. It's a native digital asset. So why do we need the functional equivalence to say that this picture is equivalent to a normal picture in this sense? I mean, the digital picture lives in the world of the digital assets. Only is physical picture when you print or even when you show the picture by the cell phone. I mean, this is the concept. And so and lastly, okay, but our laws need or require possession to transfer documents. All of you have mentioned possession. To necessary is the instrument that we have in our laws to transfer movable things or things in general. We need the possession. And my question is, we need the possession because the law says that we need the possession. But what's happened if the law says on digital record, on electronic records, that we don't need the possession, just we need the control or other terms? I don't know if the control is the correct one, but other term. And probably the answer, okay, we are not going to change all the rules to eliminate the word possession. And my answer is, why not? Yesterday, we were talking about MAS, the autonomous ships. And yesterday, a lot of speakers mentioned the possibility to amend conventions, amend legislation, amend, etc. A lot of things. If we are, or even create new ones. So if we are assuming the possibility to amend international conventions for the introduction of MAS on the maritime law scenario, why not? I'm sorry, this very enthusiastic approach. Sorry. Why not to change the current law to says that we don't need the possession in case of an electronic record or digital asset or whatever? Because remember, we are talking about in the debate, we are in the debate on possession versus control, because the law says that we need possession to transfer electronic bill of ladings, possessory notes, checks, or whatever other document of title. Okay, my solution, sorry, my solution, that's not my solution, but probably one solution is, okay, we're going to change the law. We need to change the law. We are dealing with a new technology, very, very new technology. Probably no one in this room, obviously I'm including myself, exactly know how this technology works in deep. But what I'm saying is the document is not a record. It's not a record. Some functions, yes, they share some functions, but many other functions not. Sorry for this. Introduction. Because I prefer this debate than the electronic cargo, the negotiable cargo document, obviously. But I'm going to say some words about the the negotiable cargo document. Okay, I was how to explain, but all of you know how a bill of lading works and the difference between bill of lading and consignment note. The main difference. So same evidentiary functions, but the main difference is the bill of lading as a document of title, consignment notes, CMR consignment notes, rail consignment notes, air by wheels, etc., are normally not document of titles. Why are not consigned document of titles? Because in many cases, the law, again, the convention says, for example, the Sin-Cotif convention says consignment note shall not have effect as bill of lading. So there is an express provision on the convention to the consignment note functions as a document of title. Okay, and the question is there a demand for negotiable consignment notes? When I say negotiable consignment notes, the UNCITRAL working group used the expression negotiable cargo document. So when I say negotiable cargo document, I'm referring to a negotiable consignment note, CMR consignment note, air by wheels, SIM consignment notes, etc. Is there a demand for that kind of document? And probably yes. And my answer is based on the expansion of non-maritime transport worldwide. I mean, from 5 or 6 centuries ago, the maritime law has been international. So from its origins, maritime law has been international. But inland transportation by road or by train normally has reduced to a national transportation or even regional transportation. For example, in Europe, transportation by road or by train in Europe or in South America or in the United States and Canada or Mexico. So very regional transportation or even national. And the problem is nowadays, no maritime transportation has been more international in the sense that nowadays a truck can load a container and go to Russia, or a rail comes from China to Europe. So this internationality or internationalization of the non-maritime transportation has created a necessity for the industry, the necessity to finance the operation, the international operation, okay? And when you need to finance the operation, or when you want to transfer the goods from a third party, in that precise moment, you need that the document must be negotiable. And in 2019, China submit a proposal to the UNCITRAL Secretariat to create a new instrument on a negotiable transport document to uniform the international transport documents in the sense or in the function of a document of title. Okay. So the Secretariat of UNCITRAL create or mandate the working group number 6. The group number 6 have in that moment has finished their work on the judicial sale of ships and assumes the labor to continue working on transport and with the Negotiable Cargo Documents Convention. This is all of these sessions. I'm part of the Spanish delegations at UNCITRAL drafting this convention. Very important for this convention is it's not a convention draft by academics or even lawyers. Sometimes at UNCITRAL happens that the conventions are drafted by academics or some lawyers, etc. In this convention, there are a lot of non-governmental organizations participation on the debate. FIATA, CMI, International Federation of Freight Forwarders Association, BIMCO, International Union of Railroads, COTIF, Air Transportation Association, ICC, Global Shippers Forum. So there are a lot of participation of the industry because the industry is quite interesting on the debate. I'm not saying it's interesting on the convention because presents some problems, the convention, but it's quite interesting on the debate. Very quickly, the scope of application is for international transportations between different contracting, between a contracting state in origin or a destination. The material scope is the negotiable cargo document, etc. I'm not going to enter in the detail. An important thing is who and how will issue the negotiable cargo document. Well, the convention needs or establishes a need to an agreement between the consignor and the transport operator. TO is transport operator, is the contractual carrier, not the actual carrier, but the contractual carrier. Issue and sign this negotiable cargo document by the transport operator. And this is the most important part of the convention, the dual track approach. Why I say this? Remember, I said at the beginning of my presentation, several conventions prohibit the function of document of title to their consignment note. The COTIF convention says the rail consignment note shall not have the function of document of title. Article 6.5 of the convention. So if there is a provision of the convention, why we are talking about to create a new instrument, a new negotiable instrument for rail transportation, if there is express provision. With this idea, the working group has created a dual track approach. The default rule or the first approach is to use a traditional transport document, a consignment note, as a negotiable cargo document. So if you have a CMR consignment note for road transportation, you can use this consignment note as a negotiable cargo document, putting a stamp or an annotation on the document saying, this document is a negotiable cargo record, negotiable cargo document. Why it's possible with the CMR consignment note? Because CMR does not prohibit to use the consignment note as a document of title. But what's happened? Or for example, the FIATA multimodal bill of lading. The FIATA multimodal bill of lading can be used as a negotiable cargo document for multimodal transportation. We don't have in force a convention on multimodal transportation. We have a convention on multimodal transportation from 1980, but if I remember correctly, it's not in force. So the national legislations has the power to decide if the multimodal transport document is negotiable or not. For example, in Spain, in my country, a negotiable cargo document, so a multimodal transport document must be issued as a negotiable document if there is a leg involved, it's a maritime leg involved in the transportation. In that case, the multimodal document must be used as a document of title, but probably in other jurisdictions not. So this is the general rule. Use or put a stamp and use the traditional transport document, a consignment note, as a negotiable cargo document. So in these cases, you can transfer the goods, transferring and endorsing the document as the same manner as you transfer the bill of lading. So you are saying negotiable cargo document in these cases is equivalent to the bill of lading. But what's happened with the consignment note as the rail consignment note, that their conventions prohibit to trade the document as a document of title. In those cases, the second approach is the fallback rule, says, okay, we are going to issue a separate negotiable cargo document. So in this case, we have the traditional consignment note that is not going to serve as a document of title because it's prohibited by the convention, and a negotiable cargo document. So we are going to have two separate documents. As these two documents, one non-negotiable and the other one negotiable. Okay? But both documents are under the same transport operation. So in that case, this is the most important point and probably the most problematic point is what's both documents okay, sorry, I'm trying to explain the word. Are going to go, okay, are going to go joint, but separate, okay? So if you can negotiate with the document, you are going to transfer the negotiable cargo document, not the consignment note, because it's not possible. So if you want to finance the operation through a documentary credit, you are going to transfer to the bank the negotiable cargo document. Okay? This is quite tricky and quite confusing, and this is one of the most problematic aspects of this convention, this dual track approach. I'm not very convinced of this dual track approach because what's happened if the two documents or are transferred separate? Okay, sorry for the use transfer because transfer is legal meaning. Are separate. What's happened if the consignee has the traditional document, the consignment note, but don't have the negotiable cargo document? Can the transport operator deliver the goods to the consignee? And the answer is no. The answer is no. But he has the consignment note, but the answer is no because a negotiable cargo document has been issued. And in the consignment notes is going to appear an annotation saying, okay, this is a consignment note, but in this consignment or under this consignment note, a negotiable cargo document has been issued. Okay. This is an imagine of an example, CMR with the stamp or negotiable cargo document. Okay. I'm not going to enter into, because I don't have time, into the content of the convention, but the convention establish what is the content of the document, what is the evidentiary effect or functions of the negotiable cargo document, what are the rights of the holder of the negotiable cargo document, what's happened with the delivery of the goods in case of a negotiable cargo document, and how works the transfer of rights under this negotiable cargo document. So you can read the slides on the website, and obviously you can read the convention. It's quite interesting because the aim of this convention is very I mean it's quite important to create a new function on the non-negotiable document. And I mean, for me, it's quite interesting. The approach is quite interesting. The aim, the objective of the convention. I don't know if the result of the convention will be satisfactory for all. And lastly, and in my last 1 minute, the convention established a chapters on the electronic or negotiable electronic cargo records. Okay, so chapter for the negotiable cargo records in paper, and another chapter on the electronic negotiable cargo records or electronic cargo document. There is a proposal from the government of Singapore saying we don't need a chapter on the convention on electronic records. And why? Singapore says, because we have the model law on electronic transfer of records. So the proposal of Singapore is the provision on electronic documents be replaced with a single general provision requiring the state parties to adopt under national law the UNCITRAL model law. This is the solution of Singapore. There is an internal debate on the working group, and most delegations prefer to maintain the provision on electronic negotiable cargo documents under the idea that in 2024 and probably in 2025, when the conventions was approved, if we are not dealing with electronic records, with the electronic documents, what we are doing? I mean, we are creating a convention for paper documents on 2025. I mean, it's quite difficult to sell this idea to the society. So probably the solution will be to put a chapter on the convention on electronic records, but base this chapter on the model law on electronic transfer of records under, again, principle of functional equivalence, blah, 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 as I mentioned at the beginning. So we are going to continue with the model of the model law of UNCITRAL on electronic transfer of records. So that's it. Thank you very much.